We're out of control.
Out of control.
Dylan's like, can we move this along, please?
All right, I think I'm good.
Oh, I see. Let me put myself on mute.
All right, you're live.
All right, thank you very much. Good afternoon. Welcome to the House Judiciary Committee for our bill hearings. Today is the 18th of January, 2021. Members, remember to put yourselves on mute and only unmute when I recognize you to ask a question. After a witness testifies, you can ask questions selecting the raise hand feature, which we spent some time with this morning, on your Zoom window. I will recognize members in the order in which they raise their hands. I'll be doing as I did last week, where we will, I'll take groups of witnesses and try to do them all as a group so that we have the right people to answer questions if they come up. Members, please set yourself, I said that witnesses, you'll unmute yourselves when I recognize you to present your testimony. After you present your testimony and answer any questions from the committee, you'll exit the Zoom hearing room. At all times, members of the public will be able to access and view the live stream of this meeting. It's accessible on the Maryland General Assembly website. Per our guidelines, the following bills will be on the 2-in-1 rule, which is 2 minutes for the sponsor and 1 minute for witnesses. House Bills 3, 100, 411, and 324. These were all pieces of legislation that were passed in the last General Assembly session and are in the same posture as they passed the House. The following bills are going to be on the 3-2 rule, and that's just one bill. That's House Bill 89. That'll be 3 minutes for the sponsor and 2 minutes for the witnesses. For each bill, after I introduce the sponsor, I'll try and give an indication of how many witnesses we will have answering questions with the sponsor. So with that, the first bill is my bill. It's House Bill 3. There are a total of 6 witnesses beyond me who are going to testify on the bill. I understand that State's Attorney Mosby, I don't believe she is on the call on the Zoom, and I believe she had another commitment that will make her unavailable today. But there are 6 others who are testifying in favor and 1 testifying opposed. So what I think we will do is we'll go ahead and I will testify, and then we'll take the 6 people who are Calvin McNeil, Lila Meadows, Daryl Green, Samantha Blau, Margaret Berry, and Philip Karoom, Judge Karoom. Okay, and with that, it's the first time for everything. I'm setting the two-minute clock and making sure it works. There we go. I want to thank the committee for considering House Bill 3, legislation that would remove the governor from the parole process for people who receive sentences of life with the possibility of parole. There's no question that this group of people have committed and have been convicted of terrible crimes, including first-degree murder, attempted first-degree murder, first-degree sex offense, and first and second-degree rape. However, they were sentenced to life with the possibility of parole. They were not sentenced to life without the possibility of parole. Life without parole only applies to first-degree murder. The state has to ask for that sentence, and then the jury decides whether or not to grant life without parole. The parole process is significant for people who were sentenced to life with the possibility of parole. They meet with 2 parole commissioners. The parole commissioners are appointed, all the parole commissioners appointed by the governor. They consider victim impact statements. And they, as part of that meeting, if they feel that the inmate is not ready for parole, if they give an unsatisfactory review, then that inmate would have to reapply, or they do have to reapply. If they don't express remorse, or if they haven't obeyed the rules inside the Department of Corrections, they get knocked out of the parole process. If they get through that hurdle, they have a psychological risk assessment. Right now, there's a 12 to 24 month wait time for that risk assessment, and we have one person in state government hired to do it. That risk assessment then makes a recommendation, and it is sent to two further commissioners, and with a satisfactory or unsatisfactory recommendation. Then the commission as a whole has to make an en banc review of the decision. Under current law, the governor then gets a final decision, a final say, even though the governor's office doesn't have special expertise in vetting candidates. In my opinion, politics shouldn't have any place in this process. They go through an extensive process, and if they do, those inmates do what we ask them to do after that, in fact, heinous act, then after 20 years, they should be able to go through the process, and if they make it through the process, the parole commission's decision should decide. With that, that concludes my 2 minutes, and I will begin by calling Calvin McNeil if he is on, and it looks like he is. Mr. McNeil. I see Mr. McNeil in the Zoom.
Yes, I just took myself off and mute.
All right, there you go. Mr. McNeil,
Okay.
for 1 minute, please.
Yes, sir. Good afternoon, everybody. My name is Calvin McNeil. I spent 4 decades in prison for a crime that I committed as a juvenile. I was recommended for parole and commutations 3 times, which I was turned down by Governor Hogan twice and Governor O'Malley once. The full parole board recommended me for these to be released, and the governor turned me down every time because there's politics involved with this. But Merlin Mosley, the Maryland Baltimore State's Attorney Office, just released me July of 2020, Judge White, because she said that after reviewing my record and everything, that she felt that I achieved everything that has been asked of me to be released, and she automatically recommended that I be released that day. But it took several other days. But if it wasn't for Judge White releasing me, I would still be in prison right now because of Governor O'Malley saying that I have not taken responsibilities for my actions of my crime, which I have done every time that I went for parole. I showed full remorse and accepted the responsibilities of my actions of my crime. And it's too much politics into this right here, because a judge and a jury didn't sentence me to life without parole. They didn't look at politics when it came to this. And I truly feel that no governor should have a role in saying who can be released and who can't be released. I feel that.
McNeil,
Yes, sir.
McNeil, I need to stop you here, but I believe it is possible that a member of the committee is going to have a question for you in a moment. So
Yes, sir.
I need to continue with the further testimony, but please stay on the line, okay?
Okay.
All right, thank you. Thank you very much. I need to go to Lila Meadows for 1 minute, please.
Good afternoon. My name is Lila Meadows, and I'm a faculty member at the University of Maryland School of Law. I want to thank the committee and my delegate, Chairman Clippinger, for ushering this bill to a veto-proof majority on the House floor this session. I testify in support of this bill every year based on my experience as an attorney representing lifers in the parole process. Every session I'm before you, I describe how vigorously lifers are vetted by the Maryland Parole Commission, and I'm happy to answer questions about that. But what I want to emphasize this year is the urgency of once again passing this bill. I have watched in horror this year as several of my clients who were previously recommended for parole but denied by the governor without any explanation have contracted COVID-19 in prison. Removing the governor from the parole process will allow the body of commissioners that the governor selects to make critical decisions about release after considering evidence of rehabilitation. This bill will in no way undermine public safety, and in the midst of this pandemic is a matter of public health. Thank you.
Thank you. Thank you very much. We'll go now to Daryl Green, please, for 1 minute. Mr. Green?
Hi, I'm Daryl Green. I want to thank the committee for having me today. I'm Daryl Green from Deep Forgiveness. I support this bill. I have been a strong advocate. I work with a young man who took my brother's life. My brother was 6'5", 255. He wanted shot put, and just as his junior year, a 14-year-old kid went behind the counter and took his shoe. Altercation broke out. He stabbed him. He died 4 days later here in shock trauma, Baltimore. That young man at the age of 14 was sentenced to life. He served 25 years in jail. And after he served his 25 years in jail, we went to court and testified on his behalf for his release, i.e. we forgave him. I just think that everybody deserves a second chance. And I don't think the politics of it should come into play. Once a person has done their time, also been vetted by the parole board, they've been approved by the parole board, I think that should be enough, because they go through enough stages in order to get to that piece, only for the governor to deny him. I just think it's an unfair process. So thank you, and I'm open to answer any questions.
Thank you very much. Samantha Blau. Are you here, Samantha?
That person is not in our waiting room or in the meeting.
Okay, that's fine. Is Margaret Berry here?
Yes, I am.
Great, go right ahead. You have a minute.
Okay, thank you for this opportunity to testify in support of HB3. I am a faculty member at American University Washington College of Law, and we represent juvenile lifers in the Maryland system. I come today, though, as a member and on behalf of the Montgomery County Women's Democratic Club. WDC is one of the largest and most active Democratic clubs in the county. Why is this legislation a priority for WDC? It's a matter of justice. Maryland Parole Commission assesses life or parole with painstaking and often confounding deliberation. If parole is recommending, the governor in all but very, very few cases denies it. It's a matter of cost. Maryland taxpayers pay approximately $70 million a year to incarcerate lifers, many of whom should be out. And race. Race plays a role in how harsh we've been. Maryland has the unbelievable distinction of leading the nation in its incarceration of Black people. Part of this is attributable to lengthy sentences and grim parole possibilities. One step towards addressing these failings is to remove the governor from the parole process, and we urge you to do just that. Thank you, and I'm happy to answer questions.
Thank you very much. All right, Philip Karoum, Judge Karoum, speaking for himself and not for the judiciary. I gotta save him a little bit of time, I guess, in his minute. Judge Karoum.
Thank you for that savings. So I'll add that I have been in the legal system for over 40 years, more than half of that time, though it doesn't seem so long, as a judge. Whenever I have been involved as a prosecutor, defense counsel, or a judge with a murder case in which life or life without parole has been involved, I've taken great pains in explaining the difference to a jury or to the defendant at the time of sentencing. And when governors consistently veto the possibility of parole, it basically turns us as judges and prosecutors and defense attorneys into liars, into untrustworthy people, because the things that we're promising don't happen. We want our court system to be one in which what we say is reliable. If I could add one other thing, our group, Maryland Alliance for Justice Reform, a couple years ago invited former Governor Glendening, who invented Life Means Life. And he, at that point, stated publicly it was one of the worst mistakes he had made as a governor, that he did it for political reasons to try and get to the right of the candidate that was running against him, and that he urged the Maryland General Assembly to repeal this and prevent other governors from making the mistake, because it's a power you don't want. It's a no-win proposition. If you're the governor, you're always going to disappoint someone if you permit a parole or if you veto the parole. So along with the other things that folks have said about the economics of it, I strongly, on behalf of major, support HB3. Thank you.
Thank you very much. There is at least one question so far. There may be more. We'll start with Delegate Bartlett, please.
Thank you, Mr. Chairman. My question is for Mr. Green. Mr. Green, thank you for your testimony. Could you walk us through how you and your family came to find forgiveness? What was it, after 25 years?
Yes, ma'am. Thank you for your question. I will say to you, it was a tough journey. It continues to be a tough journey. Not everybody in my family was in favor of it, but I had to walk my own. This is my own journey, but and a good number of our family members who was not so forgiving or any of that initially are now there. What I did not mention is that we not only went to court, my dad and I testified on his behalf. We now work together. The young man and I now work together who took my brother's life, and he is so remorseful. And we're on a journey of redemption right now. We speak all over the country, internationally and globally, on healing, reconciliation, and forgiveness. And what we do with it, him and I help folks to heal, right? Because listen, he did not walk an easy walk when he went to jail at age 14 to an adult institution. Imagine going to an adult institution at age 14 years old and staying there for 25 years. He could stay there for 50 years or 75 years, delegate, but it would never bring my brother back, right? And so what we tried to do is to change it around and make my brother's name, Reuben Cotton, means something, right? And so myself and the young man who took my brother's life, we work together daily, spreading the message of healing, reconciliation, forgiveness. But initially, not everybody in my family was on board. And I'm a professor. I'm a full-time professor at the Morgan State University in the School of Social Work. And so that has been our mission, just really trying to help Baltimore and other folks around the country to heal. But it was a journey. It was a struggle. Yes.
I figured it was. And thank you very much. And,
Yes.
Honor to you and your family.
Thank you.
Let me, I'll ask questions for Mr. McNeil. Mr. McNeil, are you there? Need to go back off.
Yes,
mute,
sir.
Mr.
I'm here.
Great.
No, I'm right here.
Thank you very much. Let me ask you a few questions and let you kind of finish the thought where I had to cut you off there a moment ago. How long did you serve inside the Department of Corrections?
I served 39 years, day for day, sir.
You said that you had gone through
And from the age of 16, I went for parole. I've been up for parole 7 times. I was turned down by Governor O'Malley for commutation, and then in 2018, I went up for parole, was recommended, and it was waiting for my evaluation. And Governor Hogan turned me down in January of 2020, and then 6 months later, he turned me down in July for parole and accommodation, and that was all within a 7-month period. And then in 2000, later on, my lawyers and them filed for a modification through the court system, and State's Attorney Mosley recommended that I be released to Judge White. Like I said, if it wasn't for State's Attorney Marilyn Mosley and Judge White, I would still be locked up because of Governor Hogan's decision, which one thing he said that, and I will hold true, he said that I never took responsibilities for my actions, for my crime. And each and every time I went up for parole, I always took responsibilities for my actions. I never said I don't or I didn't do it. I always, every parole board, because that is one thing they always ask you. And like I said, I've done that when I was 16 years old. And as I grow, I'm matured. So I had to start a healing, and I had to ask, even though my victim wasn't there, I had to ask for forgiveness, even to my victim through prayer. So, like I said, they're playing politics, and politics shouldn't play a role in decisions like that. Because I know is no one, I don't care how old you are, has never made a mistake in their life that they regret of doing. Even if they haven't got caught, they have done something that they regret doing in their life. And that was something that I have to live with each and every day. So I try everything in my power to discourage people from breaking any law, and as well as trying to help them to heal, victims to heal. Because I feel that pain. While I was inside there, I lost all of my parents, my grandparents, my mother, my father, all of my uncles. I am the oldest male in my family. And I'm 56 years old, going on 57. But I am the oldest male out of all of my grandparents' grandchildren. I have no more aunts and uncles alive. And I wasn't there for any of that. I couldn't go to the funeral or nothing. So, like I said, I'm still growing, but I'm not bitter with anybody. No, I respect everything that has happened. I accepted that. And I want everybody to know we're not bitter, but we shouldn't have to have people playing politics in our lives, because there's a lot of men that are still locked up that deserve to be home, because they are showing and doing everything that we're asked to do, from the parole board to everybody else. We go well and above to do everything that we're asked to do, because we don't want to be locked behind it. We want to be out in society and basically giving back to society. We know that we have a lot of things to offer society and help these youth out here. So that's all I try to do, is help many of people as I can outside here. I'm doing successful. I have a job, a full-time job. I work each and every day. So I'm not out here committing any more crimes or anything like that. I'm out here being a productive citizen.
Mr. McNeil, you indicated you're working now. If you don't want to tell me where you're working, that's fine. What are you doing?
I work in storage moving company, a storage company where we deal with and we move military peoples, we storage their property and things like that. So that's where I work at full time.
Okay, I have a few more questions. I think one of them is directed to you, Mr. McNeil, but I'm not sure where Delegate Conaway's question is directed. So I'm going to go now to Delegate Conaway for his question.
Yes, sir.
Thank you, Mr. Chairman. Thank you, Mr. McNeil, for coming
Yes,
in.
sir.
Fine. In reference to what the governor said, where he said you didn't show remorse, was that given to you in writing as part of the reason for rejection, or was that told to you orally?
Well, sir, I am the first person that he had to make a written statement. I was the first person that he had to do that for.
So you do. So there was a written statement that said you never showed remorse.
Yes, sir. That was the first statement that he had to write, and he had to do. He done that in 2019.
Thank you so very much. Have a good.
Yes, sir.
Thank you, Delegate. Thank you, Delegate. Delegate McComas raised an issue or raised a question. I'm not sure if you want to ask your question, Delegate McComas.
Yes, because I think the fact that he's working now and busy, I wanted to know what a typical day for you was while you were in the system.
Yes, ma'am.
And basically, I'm looking for whether you were able to get some educational credits or if you were working a job in the system.
Well, as I proceed, I will wake up. We will go to eat, and then if some of us had jobs, some of us worked in MCE care, where we were working the shops, what we call the shops. I worked in a meat plant where we produce and we cut meat up for the whole state of Maryland, as far as institutions, colleges, and things like that. And you had other guys that work in a upholstery shop. We had worked in a laundry shop. But that was a regular day for me. Go to work, then I will come back to where I was housed at, and that was it. Some of us at one point we could get college credits and things like that, but that was somewhat taken away. So we would have self-help programs that we introduce to others and try to help others gain an education. We help with tutoring, things like that. We help them with law and investigating their cases and things like that. So that was a regular day for me.
Thank you, sir.
Yes, ma'am. You're welcome.
I want to thank you very much. I don't see further questions for this panel. However, as I said at the beginning, Samantha Blau was signed up to testify orally. We did not bring her in from the waiting room. We have her now, and we're going to go ahead and give her her minute and then take questions, if any, for her. Then we will go on to the opponents of the legislation. And so with that, Samantha, are you there?
Yes,
Great, go right ahead.
thank you. So thank you, Chair Klippinger, members of the judiciary. My name is Samantha Blau. I live in Baltimore City in District 46. I'm here to testify in support of House Bill 3 on behalf of Jews United for Justice. So I would like to thank my representative, Chair Klippinger, for submitting this bill. It reminds me of an important piece of rabbinic commentary on the Talmud. The Talmud says that we should allow for sentences to be lifted, so basically parole, and because people should be given the opportunity to make amends or atone for their misdeeds. And Rabbi Esfeli gives this commentary and says that you can't make an amend, you can't make an atonement if you are being sentenced, if you are being held, if you are in jail. So expanding the parole process would expand the ability for people to have that moment, not more than a moment, but that atonement that is so important for true justice to be achieved in our state. So I urge a favorable report and thank you for your time.
Thank you very much. Are there questions for Ms. Blau? All right, seeing none. Thank you very, very much. I'm glad that we were able to get you in. With that, we will go to testimony in opposition, and it's the state's attorney for Baltimore County, Scott Schellenberger. Mr. Schellenberger, are you on the line? There you are.
I am. Mr. Chairman, thank you so much. Members of the committee, Scott Schellenberger, State's Attorney in Baltimore County. A couple of things. One part of the bill we haven't talked about is the inequity of first-degree murder and second-degree murder. As we've known, the statute for years has said that if you're convicted of second-degree murder and get 40 years, you get a parole hearing at 20. If you're convicted of first-degree murder and you get life, you get a parole hearing at 15. That doesn't make any sense. But this bill also does not really fix that problem, because now if you get 40 years, you get a parole hearing at 20, but if you get life, you also get a parole hearing at 20. That really doesn't make any sense, and I would say that it should be amended to raise that number up so it's more logical. The second part is taking the governor out of parole, and this is a bill in search of a problem that no longer exists. I updated my written testimony by finding out that Governor Hogan has paroled 26 people serving life. He has commuted the sentence of 22, and he has granted medical parole to 7. So this bill, while maybe it had some underpinnings 15 plus years ago, really doesn't need to be around now. All of us are used to checks and balances. This subcommittee can't pass law. The House has to do it. Then the Senate has to do it. Then the governor has to sign off. Parole should be the same way. Parole board recommends, and the governor can either grant or deny. 55 people are out because of this governor and the prior governors.
Thank you very much. There is a question for Mr. Schellenberger from Delegate Carden. Delegate Carden.
Thank you very much. And thank you, Mr. Schellenberger, my good friend and colleague from Baltimore County. Let's just say, for the sake of argument, you've got a 70-year-old man who's been in jail for 40 years for murder. And he's been recommended for parole, for medical parole, and he has a detainer against him by immigration, basically saying that as soon as he is paroled, he'll be asked to leave the country and be done in a way that is by United States immigration standards. But yet the governor refuses to parole him. And the recommendation has maybe happened 3 or 4 times over the course of his tenure, over 20 years since he's been eligible. Why shouldn't we at some point say, you know what, this shouldn't be political, which it sounds like it is. It's the only reason it would be doing that way. Sorry for such a long question.
That's okay. Thank you, Delegate. The one thing that obviously we haven't talked about at all in this hearing is the victims. Let's not forget that 70-year-old killed someone's, child, mother, brother. They don't have that person ever again in their life. And there are some people whose sentence to life is appropriate. Now, obviously, if the governor is not releasing that person, even knowing they're going to be booted out of the country, then there must be a very, very good reason behind that. And so that's the place where we have to take a look. So the governor now, because of the bill that you all passed a couple of years ago that Mr. McNeil referenced, the governor now can't just ignore the parole recommendation. You all passed a bill a few years ago that within 180 days, the governor must take action. And now, because of an executive order, the governor has to put it in writing and reasons. So all of that can be reviewed and understood. But again, what everyone forgets is behind every one of these cases is a victim's family and what may be the appropriate punishment for the crime that was committed.
Thank you. I just wondering, the Parole Commission does take into account victim issues of victims as well, doesn't it?
That is correct. The victims are always given notice of the parole hearing. They have the option to submit something in writing, or they can actually appear at a different time in front of the commission. And I'm aware that that's still ongoing, Delegate. Yes, you are correct.
All right, thank you very much, Delegate Carden. We'll go to Delegate Arakan, please. And I do need to say, with respect to witnesses who are here and are in the chat, just as we would not allow people to speak on the other side when the other side is testifying, we are going to limit the ability of people to use the chat function to effectively offer back and forth while the other person is testifying, and we're just making that as a rule here going forward, just out of respect for everybody who's going to testify here today. With no disrespect to any of the comments that are made, no disrespect to the passion on both sides. It's just we want to make sure that people can say what they're going to say and not have a running debate in the chat section at the same time. And with that, Delegate Arakan.
Thank you, Mr. Chairman. My question is actually for you. What does it look like in other states? Or how many other states have removed the governor from the process, and which ones, if you have that?
I can provide that information to you. You've caught me a little off guard. I know that Oklahoma just passed this. Oklahoma just passed this rule, so quite the liberal bastion. But having said that, I'm on the affirmative side, so let me take it back to questions for Mr. Schellenberger. Does anybody else have questions for Mr. Schellenberger? All right, seeing none, thank you all very much for coming.
I believe Delegate Conway is waving.
Oh, is Delegate Conaway waving? I apologize.
Sorry for breaking the
Go
two
ahead.
bites.
Go ahead.
Mr. Schellenberger, I appreciate your testimony and your comments, but according to Mr. McNeil, the letter that was written and that was given by the governor was not accurate. Would you like to comment on that?
Well, I candidly admit I do not know the details of Mr. McNeil's case. It was not my jurisdiction. I do not believe. I believe if he got a letter that was inaccurate, he would have litigation or some type of remedy through the court system, or could obviously go back to the governor's office and point out why it was inaccurate and show him why. And that might have changed the governor's mind. But I don't know specifically about Mr. McNeil's cases. I candidly admit that.
And you really believe what you just said to me?
I believe that if there's a misstatement in a fact that the governor has written, there should be a remedy for that. I do believe that.
Thank you very much.
Thank you very much. I think that concludes any further questions. I don't see anyone waving or electronically or corporeally.
Thank you.
Thank you all very much. That concludes the testimony on House Bill 3. Committee, I'm going to be yielding to the vice chair here. I need to step away for a moment, and we're going to go next to House Bill 100 that I think only has 2 witnesses. I think it's Delegate Davis and Janet Emanuel. So why don't I can kick off 100 and the vice chair will take it from here. Thank you. Go ahead, Delegate Davis.
Thank you. Thank you, Mr. Chair. Good afternoon, Madam Chair and members of Judiciary. I'm here to present HB 100, and it's entitled Correctional Services Inmate Cost of Living Report. This bill passed unanimously out of our committee last year, and Delegate Aragon, it was HB 979. This bill requires the Public Safety and Corrections to add 2 items to their annual report, to their existing annual report that they already do. And the first thing it would require was reporting of incarcerated individuals' cost of living, including but not limited to the cost of phone calls, video calls, food and basic medical goods available for purchase at the commissary. And second, it would disaggregate the wage scales and job classifications of Maryland Correctional Enterprise by race, age, and gender. And the reason is that families of incarcerated individuals bear the burden of these excessive costs. They often provide funds for incarcerated family members. My office has received numerous correspondence from several incarcerated individuals testifying to the steep price steep price increases and for food and hygiene products, while wages remain stagnant, some below $1 a day. This is important because inmates pay for soap, towels, feminine products. All of that stuff is paid for by the actual person in jail. For these reasons and others, we request a favorable report for HB 100. Thank you. And I'm going to, I'm sorry.
Thank you. And now the next person up is Ms. Emanuel. And so you will have 1 minute.
Thank you. Good afternoon, members of the committee. My name is Janet Emanuel, Public Policy Advocate with the ACLU of Maryland, and I'm here in support of HB 100. There are discrepancies in the magnitude of upcharges of goods in prisons because of a lack of records, but there's no disputing that the basic goods are more expensive in jail. Correction companies often outsource the product, so either the companies or the commissaries themselves are increasing prices, according to some reports by up to 350%. Multiple sources have reported a phone call such as to doctors, lawyers, or family members cost $20. This is ridiculously high in comparison to daily earnings. We know that only a small percentage of the prison population have an opportunity to work while incarcerated, and even then, most of them earning less than 90 cents a day. So a single purchase of a basic necessity like tampons could easily cost an inmate 20% of their monthly earning. And as Delegate Davis mentioned, families of incarcerated individuals are the ones that bear the burden of excessive costs, especially right now when most people aren't able to work behind the wall due to the pandemic. A lack of clear records on commissaries allows for exploitation and makes it more difficult to make policy and administrative decisions of how to best operate the prison commissaries. And HB 100 just simply seeks to add 2 more categories to the current reporting requirement. And for those reasons and all of the other reasons mentioned, we urge a favorable report on HB 100. Thank you.
Thank you. That was almost perfect. I think you went over by like 2 seconds. I didn't see any questions in the chat. I don't see any hands raised. Delegate McComas, I see has a question. Delegate McComas.
Just briefly, I'm kind of intrigued by this. So for Ms. Emanuel or Delegate Davis, do they bid out the products for folks to receive or to be able to buy in the commissary so that, in other words, they get a vendor who is the lowest cost on the products? Okay, that's one question. If you can't answer it, that's fine. The other thing is, I guess I'm just like, I just sort of really, it would be nice to know the costs of all these different things, because I think, and what, in other words, all right, let's say a box of tampons, if you went to Target, cost $5. So because you're incarcerated, it's going to cost you $10. So where does that extra money go? I'm just kind of curious, follow the money. And I think that for, it was my understanding, and I think Senator Carter worked on this when she was in the House. There was a big deal about how expensive the phone calls were. And it doesn't sound like that's really resolved that much. So anyway, if you could kind of find out, that would be very helpful. Because I mean, I don't get it, why it's so expensive.
Well, I'd like to take a stab at it, Delegate McComas. The first thing is, you are right, follow the money. Maryland Correctional Enterprise by itself is a $61 million enterprise, all right? And I wanna say that even if, let's say, the box of tampons costs the same for the incarcerated person as it costs for someone outside, the wage is limited to less than $1 a day. So, I mean, there is no balance. There is money being made by housing inmates, and it's not going to them. And it's not being used to benefit the actual inmates. Over the summer, a bunch of your colleagues argued on behalf of inmates getting fans. They weren't able to work, so a lot of the things that they needed to buy, they couldn't even buy if they had the money. I mean, they didn't have the money to even buy extra items that they needed, personal hygiene items and stuff like that.
Thank you.
And I would just add that, the rest of your questions are the answers that we're looking for and that we're hoping to receive through this report.
Thank you. There's another question for her first question in the committee. And I hope I'm pronouncing your name right, Delegate Thame.
No, I'll correct you on that. It's Delegate Cham.
Cham, okay.
Cham, exactly. Thank you, Vice Chair and members of the Judiciary Committee. Delegate Davis, drawn from the example of the women personal hygiene products, my question is, when an inmate needs these personal care items, are family members providing all of those resources, or does the inmate, is the inmate responsible for paying for their own and what they need? Is it a sort of a combination of both? Just kind of curious in knowing who's responsible for carrying that weight and paying for those items.
Thank you for that question, Delegate Cham. So it's a myriad of both, right? So only because of legislation like this did we even know that women that had to pay for their own. If you had unusual circumstances and needed additional feminine products, you have to pay for them yourself. All right. There is a minor amount of whatever products provided, but if you need more, you have to buy them. And the discrepancy really is your family can't buy them for you. Your parent has to send you the double the cost that you would have to pay in the jail.
Any follow-up, Delegate Cham?
No, I'm good. Thank you. Thank you.
Thank you. I don't see any other questions. None in the chat, no hands raised. So that concludes the testimony on House Bill 100. Thank you, Delegate Davis. Now moving on to Delegate Williams, House Bill 411. Delegate Williams, there are two other individuals signed up outside of yourself to testify, and this is one of those that we passed. So you will have 2 minutes, and the other witnesses. So that concludes the testimony. We'll have 1 minute. Hear an echo.
Okay, thank you so much. Thank you. Well, Chair Clippinger stepped away, Vice Chair Atterbury and the other members of this wonderful committee. I'm testifying in favor of House Bill 411, which, as was mentioned earlier, did pass out of this committee and actually passed the House unanimously last session. This bill number was House Bill 764. And I'm reintroducing this bill this session because I feel it's important that we ensure to protect our most vulnerable populations here in Maryland. And this after an incident that occurred by a Prince George's County police officer, a 6-year veteran of the force, who unfortunately found the need to force an undocumented Latina woman in exchange for a sexual act, in exchange for evading a ticket or arrest. And I've been working hard in trying to make sure that these unfortunate situations no longer happen again. And so this is, while I mentioned one incident, it's actually one incident out of many instances that have occurred over the years in a variety of police departments, unfortunately, throughout the state of Maryland. And in fact, in 2010, the Cato Institute, which is a libertarian think tank, found that sexual misconduct by law enforcement officers generate more citizens' complaints, except for use of force complaints. And so it's clear that there's been studies shown that this is definitely a concern. It was a concern that was raised against the Baltimore City Police Department in the studies and during their investigation by the DOJ. And I think we can all agree that this type of behavior should not be tolerated here in the state of Maryland, and that we want all of our residents, including our most vulnerable residents in our community, to trust that the police will indeed protect them. And so, I've reached out to the Maryland Chiefs and Sheriffs Association. You will see that they are not in opposition to this bill. They've submitted a letter of information. Last session, I did also try to reach out to the state FOP, who has not weighed in on this bill. But I am sure that they are all supportive of making sure that their police officers are operating with the highest conduct and with the highest integrity to ensure that they are really working for the people within our community. And I hope that by passing this bill, we can restore the public's faith in our law enforcement agencies. And for those reasons, I urge this committee again to give a favorable report to this legislation and pass House Bill 411. Thank you.
Delegate Williams. And next, who's up? Ms. Jordan, would you like to go?
Thank you, Madam Vice Chair. Thank you, Delegate Williams. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here to urge a favorable report on House Bill 411. We thank you for reporting favorably on this bill last session. It was unanimous in committee and in the full House. House Bill 411 recognizes that people who have requested an officer's help or who are involved in an investigation should be protected against sexual exploitation. You should be able to ask law enforcement for assistance without fear that you will be sexually harassed or sexually put upon or hit on. Maryland is not alone in this concern. You've already heard from our sponsor that there is an example of this in Prince George's County, another in Baltimore City. Other states, including Kansas and Hawaii, have also addressed similar issues in my written testimony. And we'll note that the bill contains an exception for officers with a prior legal relationship with the other person. This applies to people like spouses or dating relationships. That exception would not apply to activities involving prostitution or sextortion. House Bill 411 is really one part of Maryland's ongoing efforts to enact meaningful police reform. It's particularly important to Black and brown women who often receive just a very difficult response from law enforcement. So it's important for the issues of race equity, as well as for the general idea that people who are officers should not be having sex with other people during their performance of their duties. This is one of MCASA's top priorities this session, and we urge a favorable report on House Bill 411.
Thank you, Ms. Jordan. Ms. Shapiro?
Thank you, Madam Vice Chair, members of the committee. Melanie Shapiro. I'm the Public Policy Director with the Maryland Network Against Domestic Violence, and we are here to support House Bill 411. I would note that this bill is in the same posture as passed out of the House last year. Most notably, there had been an amendment that had been offered and accepted, and that is included in this version of the bill, which identifies that the exception for law enforcement who are already engaged in a legal sexual relationship, who subsequently somebody subsequently becomes a victim, witness, or suspect, so long as there is not a protective order in effect at the time of the sexual act in question. And we thank you, Delegate, for including that important factor in this version of the bill. Survivors of domestic violence must feel confident in contacting the police. House Bill 411 is an important step towards achieving that goal. Police officers wield an extraordinary amount of power and control over victim, witnesses, and suspects. And we feel that HB 411 addresses those concerns. And for all of those reasons, we urge a favorable report.
Thank you. Perfect timing, Ms. Shapiro. I don't see any questions, no hands raised, nothing in the chat, and no one flagging me down. So with that, thank you, Delegate Williams. And that concludes the testimony on House Bill 411. Moving on to Delegate Moon. Is this your first bill? First Moon special in front of the committee this year? House Bill 324. Again, this one was passed, so Delegate Moon will have 2 minutes, and there are several folks signed up to testify. I'm not sure if they're all here, so we will see, and they will all have.
All right, well, thank you, Madam Chair. House Bill 324. Just to be clear, folks, we already passed this bill last year. The vote was both bipartisan in the committee as well as on the floor. This is among the less controversial bills I think you will take up. All it does is it updates the decriminalization amount for possession only, possession of marijuana. Right now, that's 10 grams. It's among the lowest numbers in the nation. And so it is still a jailable offense to possess marijuana in Maryland, even for fairly small amounts, 11 grams, 12 grams. And so the impetus for this bill is that there have been reports coming out from the ACLU, the Marijuana Policy Project, that even after decriminalization, Maryland is continuing to arrest residents, disproportionately Black residents, for marijuana possession, continuing on through to the present. So again, we already passed this. Chair Clippinger worked out some of the language here, and this was Nick Mosby's bill last year before he moved over to the City Council. So I'm just trying to finish this up. I'll just give you a couple points of comparison before I shut up. Virginia just decriminalized 1 ounce. DC legalized 2 ounces. In Maryland, medical patients can possess 4 ounces or 120 grams, 12 times more than you're allowed to possess in Maryland without facing criminal charges. So very simple. Let's get this done. Thank you.
Thank you, Delegate Moon. Next, Ms. Emanuel, and Delegate Moon, State's Attorney Mosby was signed up, but Chair said that she's unavailable. So your last witness is Ms. Emanuel.
Hi, so Delegate Moon captured a lot of my testimony, so I'll be very brief. We believe that by increasing the legal limit and setting a threshold, that possession of 1 ounce or less is not enough to charge someone with possession with intent to distribute, could potentially divert some distribution charges, reduce incarcerated population, conserve judicial resources, save taxpayer dollars, and avoid the disruption of lives caused by unnecessary entanglement in the criminal legal system, especially, which is more critical now that we're in a global pandemic and our prisons and jails are amplifiers of infectious disease, such as the coronavirus. And I'll also just like to quickly address the opposition, which will say that increasing the legal amount of marijuana will increase youth use of marijuana, which is not simply supported by research. Colorado saw a statistically significant decrease in youth use after legalization, and that the opposition will also say that it's a gateway drug and will increase folks using it. But research also shows that one, that it falls to the to the theory that correlation alone suggests causation, which is just not true, and that in fact it can help be an exit drug to folks who are addicted to opioid and alcohol with helping with their withdrawal symptoms. So for all of the reasons Delegate Moon mentioned, we urge a favorable report on HB 324. Thank you.
Okay, I was muted. Thank you. There were 2 questions. I'm going to hold off. So Ms. Manuel, please don't go anywhere. There are 3 individuals signed up to testify in opposition. Mr. Kroll, would you like to go first?
I'm going to let Mr. Schellenberger go first, Madam Chairperson.
Okay, yep. Mr. Schellenberger.
Good afternoon, Madam Chair. Thank you so much. Look, I just want to point out, and I hope you see my written testimony, I attached a picture of what an ounce looks like. I mean, that is a lot of marijuana. And even if under this bill, even if it were packaged in separate packages to be sold, the presumption would be that in fact 27 grams packaged in say 7 or 8 different small packages would still be then a presumption against the state that you could not be charged with distribution. So I think that's a huge problem. Going from 10 grams up to 1 ounce is a huge leap, and therefore I don't think we should make that move. I last recall that this body had a big legislative commission that was studying this issue, and I thought we were going to wait until they came out with their recommendations on how we handle this. And I thought that that made a lot of sense. The other thing that I think is very important is almost every state's attorney's office in the state with possession of marijuana, including mine, have a diversion program where your first offense, not the civil one, but your first criminal offense for possession gets diverted. You don't go to court. In my county, you do a little community service and then the case goes away. So I believe there are a lot of solutions out there that we already have. Finally, passing a statute that creates a presumption in law. Thank you, Madam Chair, Vice Chair. I'm very sorry. Didn't have my timer on. Thank you so much.
Thank you. Mr. Kroll, who would you like to go next? You or Mr. Riley?
Mr. Riley, please.
Okay, Mr. Riley, welcome back to Judiciary.
Thank you, Madam Vice Chair. My name is Joe Riley. I am the elected state's attorney for Caroline County and the legislative chair for the Maryland States Attorneys Association. We were seeking an unfavorable report for this House Bill 324. Mostly, we would like to focus on page 10, line 27, the presumption area. Already, any crime would have to be proven beyond a reasonable doubt, which is the highest burden that exists in law. This would create another presumption that would put the state in more of a difficult position when it comes to prosecuting cases. And certainly the State's Attorneys Association can foresee a day where this is not just applied to marijuana, but to other substances. That's why we are opposing this piece of legislation. This body has the ability to make marijuana legal. As long as you are choosing to keep it illegal, I don't understand why you are making it harder and harder for us to prosecute it. You have the ability to do one or the other. Thank you for your time.
Thank you. And Mr. Kroll.
Thank you, Madam Chair. Good afternoon, everyone. Welcome back. Nice to see everyone today. I'm smiling at this point in time. Hello, Delegate Boone. Nice to see you too. I'm Stephen Kroll, the State's Attorney Coordinator and the Executive Director of the Maryland States Attorneys Association. And I'll simply say, please read Mr. Schellenberger's opposition and please read Mr. Potashnik's opposition, especially to the presumption. I've never seen the defense agree to any presumption, and they should not be in favor of any presumption when it comes to this. So I encourage you to read that. And we are, again, opposed to House Bill 324, and we're happy to answer all questions. Thank you all very much and welcome back.
Thank you. So far, there were 2 questions, Delegate Grammer and then Delegate Conaway. Delegate Grammer.
Thank you, Madam Chair. Question for the sponsor. Is this in the same posture as last year?
Yeah, I'm surprised there are so many prosecutors lining up against this bill, which we already passed last year.
And what happened last year? Was this a COVID derailment or was there friction in the Senate?
No, there was no issue in the Senate. We just ran out of, this is one where I would say we truly ran out of time.
Ran out of time. Question for the prosecutors, if I may. So this is a tricky one where I definitely understand the the issue with wanting to retain what you can to actually prosecute people who are at least suspected of distribution, and this would make that a little bit tougher. But to me, it's important to differentiate between possession and distribution. And I know a lot of people that have gotten, really just innocent people that would never distribute, that have gotten wrapped up in trouble because they've been suspected of distribution. So isn't there a more effective way of really making the system flexible and identifying people who are guilty of distribution? Is it a matter of resources where we could put more law enforcement on the street to find people in the act, or am I just reading that incorrectly? And changing this law itself makes it harder to catch suspects who are actually distributing.
So this is Scott Schellenberger. Thank you, Delegate Grammer. So it's very rare for someone just to go to court and prosecute somebody for possession with intent to distribute when all you have is the drug. You typically need other indicia like scales, like observing them. You definitely typically need more. But the example I gave to you, 26 ounces, but in 5, 6, 7 separate baggies, certainly shows something different than the picture that I attached to my testimony, one bag full of an ounce. So, the problem is when you start getting up to that level of an ounce, then you add this presumption, then even if I find you with other things, there's a presumption against me to be able to prove that you're distributing. Now, maybe I can do it if I have a lot of other evidence, but it would be very difficult.
But I get that 100%, but that's also a very slippery slope. And that's in a lot of cases how people who, with firearms, there's a suspected possession issue, and all of a sudden someone gets shot to death in their bed. Why is it that we rely so much on those kind of possession related issues? I mean, is it that hard to catch someone in the act with distribution of narcotics?
Well, yes, because they know it's illegal, so they're very surreptitious about it and how they do it. But respectfully, I mean, there's a big difference between a handgun and somebody with possession of marijuana. And I understand you were trying to give me an example there, but there's a big difference between the two. But the reason that the distribution is often difficult is because they're very good at hiding what they do.
If you wanted to cover the gap and really facilitate enforcement against bad actors, and let's be frank, a lot of the violent crimes we have, especially in the Baltimore region, is due to it's petty marijuana dealers, and people don't get that. If you wanted to cover the gap and really make a robust enforcement arm while not having a slanted heavy hand against people who just used, and that's the people we don't want to target, is the people who use medicinally, the people who just use recreationally. If you really wanted to cover the gap here and make a robust enforcement arm against the distribution networks that are contributing to violent crime, aside from this bill, what would you do to do that?
Well, I mean, I'm not going to suggest that we have a lot of police out there looking for people who have a couple joints of marijuana. I mean, it is typically found when you're investigating some other kind of crime. As I said, under 10 grams, it's civil. Over 10 grams, up to a certain amount, I have to prove that there's an intent to distribute. I have a diversion program. So I mean, this really is not that big of an issue. There are not a lot of police officers out there in this state who are looking to lock people up for possession of marijuana. My point was, going from 10 grams all the way up to an ounce is a big leap. You know, maybe, I don't know, do you go to 15 grams and say, all right, let's see what everyone decides on the other part of it. But regarding medicinal, if you have the medical marijuana ability, then you can use it. You can have up to the, as the delegate said, 4 ounces.
All right, I appreciate the questions.
Okay.
Thank you, Delegate Grammer. I just want to remind everyone there are 2 other questions. So I believe the chat has been disabled. We can't let folks use the chat. It happened on another bill as well. So everything in the chat is subject to PIA, and we need to treat this like a regular hearing, and we couldn't pass notes to one another if we were all together. So if you have a question, please raise your hand or, you know, try to wave if I don't see you. Delegate Conaway and then Delegate McComas. I have you, Delegate McComas. Delegate Conaway.
Thank you, Vice Chair. Delegate Graham, I've never heard this theory of petty marijuana dealers causing most of the violent crime in Baltimore City, and I would appreciate any information that you can give me. Delegate Moon, I understand what you're trying to do, but I'd just like to be clear. Let's say if a person wanted to make a purchase of $100 and they might get 20 nickels or something like that, or 25 nickels as a special, that would be interpreted or could be interpreted that they were a distributor versus they purchased an amount, and the way that it was bagged or bundled, maybe in dimes or lids or tubes or whatever it is, equaled the money that they were spending. Is that correct?
That would be a factor, yes.
All right, thank you very much.
And just so you know, we do have violent crime surrounding marijuana, but it's not small amounts. There was a double homicide in Towson, and there were pounds of marijuana in that condo.
Yes, I can understand that, but what was said was petty marijuana sellers. Petty,
yes, sir, understood.
Quote unquote. So I
understood
that before. Thank you.
Delegate McComas.
Just briefly, do you, the state's attorneys, you all voted on it and you voted against, and as an organization voted against the bill, is that correct?
That is correct.
All right, question, do we know where the Maryland chiefs and sheriffs are on this bill? I would think that they would agree with you that they don't think it's a good idea, but I just wondered if you knew.
I don't know. I don't know where if my colleagues do.
Okay.
I don't know.
Thank you. Thank you, gentlemen. Thank you.
And seeing no other hands raised. Oh, I see Delegate Anderson. Delegate Anderson with a question.
Yeah, I thought I had raised my hand by computer.
You know what? It's like blending in with your background, so I missed it. Sorry.
I'm sorry.
Make it like you have a tan.
Okay. Mr. Schellenberger, it's been years since I've been able to correlate this, but how many regular joints or marijuana cigarettes do you get out of 10 ounces?
Out of 10 ounces or 10 grams?
I mean, out of 10 ounce, the current law.
So the current law is 10 grams is a civil
10
offense.
grams, I'm sorry.
Yes.
Right.
That's a civil offense, and you could get several joints out of that. Obviously, an ounce, particularly if you look at my written testimony, you would get a lot of joints out of that ounce. And I did attach that to my written testimony, and you can just Google ounce of marijuana and lots of pictures pull up. Although I'm not sure it was a good idea for the state's attorney to do that on his computer.
All right, second question is with regard to a person being charged with possession of marijuana, over 10 grams, or being charged with possession with intent to distribute marijuana, which of those two charges is the person more likely to get a no bail and get out quickly?
Oh, possession of marijuana, you're getting a summons. If you're arrested, you are out very quickly.
Okay, so if we were to raise the 10 grams to 28 grams, then that would be the case as well. Would you think?
Well, if you were to make 28 grams a civil offense, all they could do is hand them a ticket. It'd be like a speeding ticket.
Okay, I guess the point I'm making is that there are collateral consequences that this bill would also solve, and that is for a person who is alleged to have possessed more than 10 grams, but less than 28, who could be charged with possession with intent to distribute, and therefore possibly spend a Friday or a weekend in jail before he could get out. I think that's one of the consequences that Delegate Moon is trying to resolve.
I understand. I think, again, I have to show probable cause, not only of the amount, but some indicia that you intended to distribute. It wouldn't just be pure amount. And I think that would be difficult in what you've described. Certainly the solution to your issue is that they could be issued a citation as opposed to arrested and set in central booking. But again, I don't think you look around the state, there's a lot of people getting arrested and sitting in jail for possession of marijuana. I'd be willing to say there's none.
Well, I'd agree with that. But again, there'll be fewer if this bill were to pass.
Yes, sir.
Okay, thank you so much.
Yep.
Good to see you.
Good to see. Are you actually there, or is that just your background?
That's my background. I'm actually with Delegate Davis right now.
Okay, and with that, we will conclude the testimony on House Bill 324. Thank you. And moving on to the last bill for today, House Bill 89, Delegate Wilkins. And Delegate Wilkins on this piece of legislation will have 3 minutes to testify. And there are 4 individuals signed up to testify, and they favorably, and they will have 2 minutes to testify. So Delegate Wilkins, on to the last bill.
Thank you so much, Madam Chair, and greetings and good afternoon, everyone in the Judiciary Committee. I always enjoy being before your committee. For the record, again, I am Delegate Janelle Wilkins presenting HB 89. And I want to start by thanking the committee for moving this bill favorably to the floor last session, and I'm asking for your support on this bill again. I think it's so important and appropriate that this hearing is held today on Martin Luther King Jr. Day, when we commemorate a man who was imprisoned countless times and fought against the injustice of incarceration, of over-incarceration, and to have this discussion today in the state of Maryland, where we imprison more Black men than anywhere in the country. The foundation of HB 89 is that our prisons should be places that rehabilitate and redirect individuals in the system so that they're returning to our communities with a foundation for success and that they're returning with more skills than when they came in. This bill allows a deduction of 90 days from an incarcerated individual's term of confinement if they successfully complete an education program. So as you all may be aware, studies almost unanimously show that higher education and prison programs reduce recidivism, and it translates into reductions in crime, savings to taxpayers, and long-term contributions to the safety and well-being of the communities that these incarcerated individuals return to. However, under current law, incarcerated individuals do receive diminution credits for their length of time, for good conduct, for work tasks, for education courses. So this is in existence. However, for an incarcerated individual who completes a degree program, that monumental accomplishment of gaining a certificate, getting a degree while incarcerated, we don't award any type of special amount of diminution credits. So whether you're doing the laundry, or if you're in an education program, you're getting the same amount of credits currently. And what we're saying is for folks who complete a program to be provided this award of 90 days in terms of diminution credits. As you all may be aware, the odds of obtaining employment after being released actually increases by 13% for those who are able to get an education, participate in correctional education programs. So the numbers are really showing us that these correctional education programs are a really important opportunity for us to rehabilitate and ensure the success. I want to point you to the letter from the Department of Corrections, which is very positive and provides additional information about the need for this type of program and some of the statistics around correctional education. And finally, I want to conclude by saying that this bill is really in line with our state's goal and our previous efforts of reducing our prison population. These are individuals who are returning to our communities, and we want to really guarantee their success. So I urge a favorable report on HB 89, and thank you again for your support last year.
Thank you, Delegate Williams. Next, we have, I guess, Mr. Karoun, you want to go next? You're on mute there. There you go.
Thank you. Madam Vice Chair, members of the committee, I am again speaking for Maryland Alliance for Justice Reform, not for the state court system. I wanted to add one thing to the introduction that we appreciate from the sponsor, Delegate Wilkins, which is that this bill has passed the Senate before. We think the reason it didn't get through last year on the House side was because of the COVID interruption. The effectiveness of having a credit which is greater for educational accomplishments than for the other things which now are available with equal credit was demonstrated when the Department of Public Safety and Corrections equalized the credits about 10 years ago. It used to be before they equalized the credits when there was an advantage to getting educational accomplishments. They had about 1,000 GEDs earned per year, and there was a waiting list to get into GED classes. After they equalized those credits, the number of GEDs dropped to only a little over 300 per year. So it's a big effect to motivate prisoners to have those educational achievements. Another thing to add is that the job training also is very important. The best job training program in Division of Corrections is Correctional Enterprises, but one has to have a GED to get in there. So folks who see it as equally valuable to sweep the floor or work in the cafeteria instead of earning a milestone degree like a GED or a college degree still may not have the motivation that they need to move into that better job training program. Last thing I wanted to mention is that the fiscal impact note from a prior year has said that this would not be an expense to institute this for the Division of Corrections. In fact, it would be a minor decrease in their cost because it would, with recidivism being reduced, it would reduce the population in the long run. So for all these reasons, we ask you please to support HB 89. There are some other members of our organization, I think, who did not get registered with the MGA program to testify as quickly. These include former correctional administrators in their state prisons, the former cabinet secretary of President Obama for Education, John King, and many inmates who used to benefit.
Thank you.
Thank you.
Next, we will have Corey Johnson.
Good afternoon. My name is Corey Johnson, and I am an attorney and the Senior Policy Research Analyst at the Job Opportunities Task Force. Thank you for having me today. As Delegate Wilkins, the bill sponsor for House Bill 89 indicated, Maryland has the highest percentage of incarcerated Black people in the United States. I believe that that statistic is particularly telling to us the importance of our focus on the educational needs of our community members. Currently, just a little bit about diminution credits. The state of Maryland provides up to 30 diminution credits to certain individuals who simply participate in educational programs, but many are released without completing the without completing the program and securing any credentials. The legislation that we are supporting, H Bill 89, will provide an additional 60-day reduction for those who successfully complete an educational or vocational program. It is absolutely necessary to understand the level of systemic barriers incarcerated individuals face. The average reading level of the 19,332 incarcerated citizens in the Maryland prison system is between the 5th and 8th grade. Less than half of this population has a high school diploma when they enter the correctional system. Despite this statistic, the number of individuals enrolled in the diminution credits program is steadily dwindling. According to the 2018 Correctional Education Council report, there are between 300 and 600 youth under the age of 21 incarcerated in adult prisons. All incarcerated persons under the age of 21 without a high school diploma are placed in a class within 30 days of their arrival. Yet in fiscal year 2017, only 55 students under the age of 21 attained their GED. What this means is that individuals that have been incarcerated are leaving incarceration or re-entering society without the necessary tools to have meaningful participation within society. I would also like to highlight that studies have shown that recidivism rates, as Judge Karoun mentioned, for incarcerated persons with a high school diploma or GED or college degree are 7.9.
I'm going to have to ask you to wrap it up. The time is up. So
yes, ma'am. This is my last sentence. Are 7.9% less than the overall imprisoned population. Thank you so much for your time.
Thank you. And Christopher Dews, I believe, has just joined us.
Yes, I want to apologize. There's a bit of some confusion. William Freeman is actually going to be speaking for me. So, Will, can you hear? Yeah, go ahead and go, Will. Say what you got to say, man.
Okay.
There we go.
Hello?
Yep, you're good.
Okay. So, hello, my name is William Freeman. I'm a program coordinator with an organization called From Prison Cells to PhD, a Gallup sociology graduate, and a formerly incarcerated person of 21 years for a violent offense. I'm here to testify in support of House Bill 89, and I want to introduce this by introducing this theory of social exchange in the hopes that this committee will vote favorably for House Bill 89. And to answer why I chose this theory is because this theory has in one of its assumptions, and I can connect it to a personal anecdote. So this first assumption that I want to mention is that humans seek out reward in exchange for good to avoid punishment. So I grew up like so many other individuals who are incarcerated or on a path to incarceration in a household where being rewarded was simply not being punished. So I learned to avoid punishment. Learning to avoid punishment, however, it did not equate to good behavior, nor was it a deterrent from bad behavior. In fact, it did just the opposite. It was the impetus and the growth of my criminal thinking that came from just avoiding punishment. However, having opportunity to earn and safeguard the reward of diminution credits in prison over a period of time, it was positive results in that, and it allowed me to develop good character while learning to trust in the process instead of cheating the system. So I say that in defense of individuals who have not attained the age of 25, who have made errant decisions, and whose way of thinking or judgment has not fully developed for them to be fully accountable to an extent of no redemption, no second chance. So I share that small bit in the hopes that this committee will vote favorably for House Bill 89.
Thank you very much. And Delegate, there was one other person signed up to testify. I'm going to call their name. I don't think they're here. Will Safore, but I don't think he is here.
We actually had our intern sign up for a witness, but she is not joining us any longer.
Okay, thank you. So that concludes the testimony. There are two questions, Delegate Fisher and then Delegate Anderson. If anyone else has a question, please use the Delegate Conaway. I see you. Okay, Delegate Fisher.
Thank you, Madam Vice Chair. It's good to be here. I have a question for
Delegate Wilkins or anyone else on the panel, what types of crimes would be included in this bill?
Thank you so much, Delegate Fisher, for that question. As drafted, the bill includes any individual who currently is able to receive diminution credits also would qualify for this program, because we want to ensure, again, the point is that rehabilitation, ability to receive an education, that we want to incentivize that. So we want to ensure that everyone who is eligible for diminution credits currently are able to benefit from the credit, and that we reap the benefits as a state. And I wanted to see if anyone else on my panel could respond to that important question as well, if that's okay.
I'd like to offer an addition to that response, which is to say that we know in a prior year, there was an amendment seeking to exclude individuals who have a crime of violence conviction from getting this credit, or to reduce the credit that they were entitled to. The concern that we have is that currently, according to Division of Corrections statistics, 84.6% of everyone, all the Marylanders in our prisons, have a conviction of a crime of violence. So we would be saying that 85% would not be incentivized to do the very thing that would reduce their likelihood of committing new offenses in the future. So we would encourage you not to exclude large groups of prisoners, of Marylanders who are incarcerated from that. There's no evidence to suggest that the benefit of reducing recidivism only works for people who have nonviolent offenses. It works for everyone, as best we know. And it should be for that reason that you would not exclude large numbers of folks.
I think it's also very important to know that this piece of legislation would not usurp the governor's power in parole, specifically in regards to sentences where there is a life sentence, where the governor would need to approve that. So in any condition like that, this would not usurp the governor's sole authority to say yes or no to that petition.
Delegate Anderson? Delegate Fisher, you want to put your hand down?
I found it. My question again is to Judge Groom with regard to the language on the first paragraph of the bill that indicates that an inmate may be allowed a deduction in advance of his term, in this particular case, 90 days. Is that the art of how we put these diminution credits in? In other words, do you have confidence that if the inmate were to complete these, that not only would he be allowed, but he would actually get them? Would you automatically get them?
I believe that it would be done by action of the Division of Corrections folks who keep track of how much time has been served in their DIM credits. I don't think it's made to make it discretionary, with one exception, which is, I think, in the list of milestones for which credits are granted, one of those credits is for a vocational certification that
Right.
would be a marketable certificate that would help you get a job. Everyone knows what a GED is, what a college degree is, and so forth, but the vocational certification, there possibly might be discretion there if someone completed something that was minimal and didn't actually lead to a job. It would need to be, that would be a point upon which the Division of Corrections would need to get a list and say, if you do one of these, this is what that credit is for.
So you don't think there's a need for us to put in the words shall be allowed a deduction in advance of the inmate's term?
I think shall would be fine. I think it is intended to be largely automatic, with that sole possible discretion of we need to identify what vocational certification we're talking
Another
about.
question is one of the things that they could qualify for is in line 5 of the second page of the bill, an intermediate high academic certificate. What is that?
I feel like I should defer to the Division of Corrections. We worked with them, and I think that term came out of the discussion with the Division of Corrections, that is something they recognize.
Is it higher than a high school diploma, or is it halfway to a high school diploma? Because according to the bill, you can get 90 days off of your sentence for completing any of these.
I, again, have to apologize. That term came from the Division of Corrections, I believe, and I will find out from them exactly what it is, and I would like to get back to the committee by email.
Okay. And it's your understanding, though, that you could complete 1, 2, 3, 4, 5, 6 of these and get 90 days each?
No, it's at least the way that the bill was framed before. I don't have it in front of me as we speak. It was previously a one-time credit. If the committee wanted to make it where one could earn a credit for doing it more than once, we would welcome that, because I think that it actually would be beneficial to Marylanders who are incarcerated and to our communities if folks had more educational and job certification certificates under their belt.
Okay, I'm trying to get to the thinking of the drafters of the bill. On page 2, line 15 of the bill, it says the deduction allowed under subsection A, there's 6 possibilities, shall be 90 days per program completed.
If I can, thank you so much, Delegate. Absolutely, we've had a few versions of introducing this bill a few times. So yes, the current version states per program completed. So as you can imagine, for someone to get a high school diploma and then get an associate's degree and then get a bachelor's degree, we would like people to continue on that path towards higher education. So we want to continue to incentivize it. Of course, this will be something that is up to the committee, but yes, in the current version, we want to continue to incentivize. So if you get a GED, don't stop there, can continue on that path, and we would like to reward each completion.
Okay, and do you know what an intermediate high academic certificate is?
We would have to get back to you again. We did work with Division of Corrections, and
I don't know either.
Yeah, so we would need to get back to the committee on exactly what they were thinking with that, but that's a great question. Thank you.
Okay, and one other thing, Judge, most of the diminution credits I've heard of are awarded on a 30-day basis. In other words, you get 15 days per 30 days for good behavior, things like that. I'm trying to figure out, this would not be awarded in that fashion. It would only be awarded.
Absolutely correct. And the reasoning behind this is that the other form of credit, which is the same form of credit that you get for sweeping the floor or cleaning the cafeteria, it doesn't matter how well you do. So we don't want to reward people for just going to an educational program and sitting there, not actually working the program and earning the achievement. So by making it a milestone, you're actually incentivizing them to earn the degree, to earn the GED or the college degree or the job certification, which is obviously more valuable on the outside. If you're applying for employment or seeking to qualify for employment, the employer is not going to give you the benefit for you saying, I sat in this class and didn't achieve anything after 8 months.
Right. Okay, no, I'm in favor of this bill. I just had questions with regard to the implementation of it to make sure there aren't complications. And I would like to find out what a high academic certificate is. I had never heard of that before.
And we'll confirm exactly what that is and get back to you as soon as we can.
All right, thanks.
And next we have Delegate Conaway, Delegate Williams, and then Delegate McComas. Delegate Conaway.
Thank you, Vice Chair. To the judge, why don't we release people who can prove that they've been rehabilitated versus give them time off? of the sentence? I mean,
basically you're talking about the principle of parole. And I would agree with you that it should be the goal of the parole commission to identify folks who they think are very low risk, who are basically safe to return to the community. However, considering that there is the consideration of whatever the offense was and how long the sentence was, these credits may be still more important for folks who, if they had a long sentence, may not even be eligible for that parole hearing until they earn some dim credits and spend some time. So this is making sure that they use their time when you've got a longer sentence in a productive way.
Sure. Do you view a sentence as an amount of time to be rehabilitated, or do you see the sentence as a punishment?
Speaking for myself personally, I always have seen my sentencing, with very, very rare exceptions, as time to be rehabilitated. And in sentencing a person, I would always give them a talk at the time of sentencing saying, use this time, make yourself a better person, ready to have honest employment and a better influence on the community by the time you're released. I know that it's not always perceived that way. And in rare instances, there are some folks that we never want to come out.
Okay. And so to the maker of the bill, so delegate, the people who are charged with murder versus other offenses, they'll get the same amount of time off if they complete the programs?
If they currently qualify for diminution credits, so they're already, they can do work tasks, good conduct and things like that. If they currently qualify, then yes, they would get the same amount of credits. That's correct.
Oh, sorry.
Oh, go ahead.
I just wanted to, if it's okay, to provide a point of clarity. So under Maryland Criminal Law Code 2201, for first degree murder, individuals are either sentenced to life or life with a possibility, without a possibility of parole, right? Under the Maryland Code of Correctional Services, it indicates that once you've received that sentence, that there's only one way that you can qualify for parole, and that is petitioning the governor. Right. So once you petition the governor, the only way that you're able to petition the governor is to serve your sentence of 25 years or 25 years, the equivalent of 25 years to include diminution credits. So if an individual who is convicted of first degree murder is then receives diminution credits, they would go towards that 25-year hold to petition the governor's office. But the governor is only the sole arbiter of whether that individual can then be released or not, just as a point of clarity for everyone.
Sure. And we're looking at taking the governor's role out of this process. Do we have any victims input statements or surveys on how victims and victims' families feel about these?
That's a great question, Delegate Conway. There should be a written in your files. Hopefully that made it in from a victim. Hopefully that's there. There should be one. I can't.
I think if I had something horrendous happen to somebody in my family, I would be against all of these credits, and I want the person to bring their time to the door, and they can be rehabilitated once they get out, or need to take care of themselves before they get in. So I think this is something that really the public needs to get a hold of, and we need to get some serious input on what people think. I mean, it's nice to be rehabilitated. It's nice to be rehabilitated, but that doesn't solve the problem of the crime that was committed.
So,
thank you. So there's no question pending. Is that all, Delegate Conaway?
Yes, thank you.
Thank you. Delegate Williams?
Yes, I have a question. So I was reading through the fiscal note and I noticed, obviously you mentioned this, it was introduced last year. I see that the cross-file was passed, the Senate with amendments. And so I guess my question is whether or not this version of the bill is the exact same version that was passed by the Senate last session, or if, I guess I'm just trying to figure out what posture the bill is in. Because I also see that it did pass this committee, but then was recommitted. And I guess my second question is, why was it recommitted?
Thank you so much, Delegate Williams. Another really great question. In terms of the Senate version, I want to emphasize that the Senate has passed a version of this bill at least the last 2 years. And I really hope that we can bring this bill to final passage. It's been bipartisan passage as well in the Senate. The difference between the Senate version is that what they did was they took certain crimes and decided that some crimes would get a certain amount of diminution credits and some crimes would get a different amount. The that is what Judge Karoum mentioned earlier, which is that if we look at something like crimes of violence, that's 85% of the people who are in prison. So if we just broadly say, okay, but if you're a crime of violence, you are excluded or you get less of the diminution credits, we are really really watering down the impact of this legislation in terms of making sure that we are impacting the ability for folks to increase their skills and be able to have this strong incentive. To your second question, there was a discussion, the bill was ready to go to final reader for a vote, and there was just discussion around who should qualify, which is some of the discussion we're having in this conversation now. And so that's why the bill came back for reconsideration. And so we wanted to make sure in this hearing, we brought up the issue of why it's important to ensure that as many incarcerated individuals as possible qualify, and that just saying all crimes of violence are out is actually not a good solution if we're trying to get to the goal of this bill to offer this type of incentive to our incarcerated individuals. Thank you.
Okay, thank you for clarifying that. Thanks.
I'm back. I believe that there are still questions from Delegate McComas and then the Vice Chair. All right, Delegate McComas.
Thank you. Thank you, Mr. Chair. Quick question. Where is the Division of Corrections on this issue? Is there a letter of support in the file? And then the other question I have is that incarceration is or punishment is a three-legged stool. There's punishment, restitution, and rehabilitation. And do you feel that this system of the diminution credits for a college degree or higher education, whether it be the GED or whatever, is really supportive by that three-legged stool of punishment?
Thank you, Delegate McComas. Regarding the Department of Public Safety and Correctional Services, I did receive a letter from them, a letter of information from them earlier today. So I assume that you all have that as well. I think it's a very helpful and positive letter of information, sharing statistics and really, I think, making the case for why we need this legislation. However, it is a letter of information, not a letter of support. So I want to direct your attention to that letter. And also, I do think that this is an important piece of the three-legged stool that you mentioned in terms of the rehabilitation piece. I think this committee today has been really talking a lot in various bill hearings about redemption. And I think this issue of rehabilitation, and I think a piece of that is someone gaining skills, really applying themselves and committing to probably what would take a very lengthy amount of time to receive a certificate or a degree. And I think that this is an important piece of rehabilitation for individuals who will be returning to our communities and ensuring that they are set up for success.
I just have a quick follow-up. I meant to ask this. What if a person, completes everything and then for some reason they fall off the wagon in the sense that they get into a horrible fight or whatever? And is there a potential that they will lose some of these dim credits because of bad behavior?
It is possible for the Division of Corrections to revoke dim credits. That is one of the forms of punishment for behavior violations that occur in the system.
And Judge Karoun, just a quick question. In other words, if the credits are revoked or whatever, there is due process so the person could appeal that decision and go.
There definitely is. The Inmate Grievance Commission is a process that permits them to review that And they can also kind of argue that when they come to the parole commission.
Okay, thank you. Thank you. Thank you, Matt, Mr. Chair.
Thank you. The Vice Chair with a question, and then Delegate Moon with a question.
Thank you, Mr. Chair. A couple quick questions. My first question is, I know there's been several versions of this bill. Are sex offenders or any types of sex offenders included in this version of the bill? And then I know, Delegate Wilkins, you talked about your rationale for having people to move on and complete, once you get your GED, then get your bachelor's. I wanted to know if you, I guess, have another rationale for not considering the Senate's, which I have not seen, by the way, the Senate's different tiers and distinctions of DIM credits, because I think certainly some crimes are more horrific than others. And I mean, some, quite frankly, in my opinion, wouldn't be deserving of DIM credits. But I mean, we give out different criminal penalties because there are different levels and different types of crimes. So I'm wondering if you're opposed to that at all, if we decided to go that route.
Thank you, Madam Vice Chair, for that question. To the first question regarding sexual offenses, again, any incarcerated individual who's currently able to receive diminution credits, who are already receiving them for good behavior and good tasks, are eligible in this legislation. So yes, certain types of sexual offenders are able to receive diminution credits. I want to point out that one group that is not able to receive diminution credits are those who are serving first or second degree rape involving a victim who's under the age of 16. So there are some folks who are already unable to receive diminution credits. Regarding your second question, I did address that in a previous question. The Senate has passed this bill several times. They have gone the approach of tiering the amount of credits based on the types of crime. The issue with that, again, is that if we tier something, for example, with just a broad stroke with crime of violence, that's 85% of the people who are incarcerated. And I think that what we want to balance and ensure is that the goal of this bill is to ensure the opportunity and incentivize that people who are already returning to our communities, that they are incentivized to gain a gainful employment, gain their education. We talked about how low the education level is for most of the people who are incarcerated, and we want to incentivize them receiving education while they're incarcerated to reduce recidivism. So the more that we remove people who probably need these diminution credits and this incentive the most, we sort of get away from the goal of the bill. So I'm open to considerations of the committee, of course, in terms of how you'd like to move forward, but I would just emphasize that as much as possible, we want to ensure that incarcerated individuals are able to really benefit and incentivize to really better themselves via the correctional education system and be set up for success when they return to communities.
Chair, I just have one follow-up question, please. And I don't know if this is for Judge Karoum or someone else. So could someone just clarify for the committee? I think it would be helpful. So what types of sex offenses would be included in this? And then, we're talking crimes of violence is kind of a wide range. So are we talking, are any acts of murder, carjacking, use of gun in a crime of violence? Would those also be included under individuals who have the ability to receive DIM credits?
I can provide you the exact, in terms of sex offense, I can provide you with the exact people that are disqualified. So an individual is ineligible to receive diminution credits if they are, one, serving a sentence for first or second degree rape or sexual offense against a victim under 16, 2, serve a repeat sentence for a third degree sexual offense against a victim under age 16, and 3, imprisoned for a lifetime sexual offender supervision violation. That's to your first question. And then to your second question, just to reiterate what Delegate Wilkins said, in terms of 85% of the population, in crimes of violence, the reality is that if someone is not sentenced to life, then they are coming home. And so what does that look like for us to be reintegrating individuals back into society, but also allowing them to meaningfully and seamlessly participate? And so we just want to highlight that and make sure that that's important.
If I could add two things. One is in my former life, I was about half of the state's attorney's office sex offense and child abuse prosecution unit. And even in that capacity, I would have to say that if I were given a choice between someone that I prosecuted and got incarcerated for a sex offense, between that person being unemployed or employed full-time when they came out, I would really want them to be employed full-time when they were released after serving whatever the sentence was, and believe that they would be less likely to commit more offenses if they were busy. The second thing is our organization, Maryland Alliance for Justice Reform, has researched as best we could whether the effect of reducing recidivism, new offenses with more education applies to sex offenders as opposed to other groups. And we have found no indication at all that applies any differently, that there is a reduction of recidivism as far as the research tells us for sex offenders as much as there is for any other category of offender.
So I just want to be clear that, I'm all for giving people opportunities in not my second life, in my current, second career. That's what I do. I'm counsel to a company where we provide job opportunities, we run reentry programs and that type of thing. I do think that it's important for this committee, though, to take a look at these different levels when we're talking about crimes of violence, a crime committed with a handgun or a carjacking or something like that. I find that compelling. So thank you, Mr. Chair.
Delegate Moon, with what I believe is the last question, maybe. Or I'm sorry, I believe Delegate Conway may have a question too. Delegate Moon first.
Thank you, Mr. Chair. Welcome back. Delegate Wilkins, just a couple points of clarification as I try to bring myself back to last year's debate on this bill. The bill doesn't change at all who is entitled to be released or not released from prison, correct? This simply deals with how long they're incarcerated.
Right, that's 100% correct.
And on that point too, can you also clarify that the population we're talking about is people who are going to be released into our communities anyway, right? Like they're coming back to our communities one way or another. And again, this is just, whether it's 30 days sooner or not, 60 days sooner, right?
That's correct, Delegate.
So I recall you had raised the issue last year, and maybe you could represent this information clearly, putting aside the three-legged stool or all these philosophical things about justice and forgiveness. Do you have evidence that just as a very practical and selfish matter, that our communities are safer actually from crime by ensuring these people who are going to be released are educated before they come back to our communities?
Absolutely, Delegate. Any study that has looked at correctional education has been almost unanimous in conveying the benefits of individuals who are incarcerated obtaining this type of education. Study after study shows the benefits to the communities that they return to. It shows a reduction in recidivism. It shows the likelihood of these individuals being employed and therefore being less likely to reoffend. And so the data shows time and time again that the benefit of correctional education, which is what we're seeking to incentivize, is there.
And sorry, if I may, Mr. Chair, just to be very clear on the terminology you're using here, so I would like to put this in plain English. When you say recidivism, you're talking about committing more crimes, correct?
Correct, yes.
And so the theory of the case of your bill, if I'm understanding this correctly, is if we take even convicted violent criminals in Maryland, those who are in prison for violent crimes, but who are eventually going to be dumped back into our communities, that it is safer and they commit fewer of these crimes when they're released if we educate them first?
That is what the data shows us, and that is what this bill seeks to do.
Thank you.
Mr. Freeman, you raised your hand. Did you want to respond to one of Delegate Moon's questions briefly?
I did. I graduated from Goucher and was a part of Goucher's Prison Education Partnership. Recently earned my bachelor's in sociology in May 25th. However, Bard's Prison Initiative, they tout some really magnificent numbers. I think it's 97.5% of people who have an opportunity to take college credits don't recidivate, and that number shrinks as people's education goes up. Now, again, like the issue of violent crimes, I understand that part of prison is that it's punitive, but a part of it is also turning a blind eye to the fact that it's easier to get a gun than it is a quality education in some communities. So the fact that I have access to an Army-issued assault rifle for less than $100, however, the school I go to, who reduced its graduation rate from a C and saying you could get a D and still pass and get a piece of paper and say you went for 12 years, is also a type of violence that must be ignored. But we get to the point where the individual got access to a gun and ignore the fact that the individual didn't have access to quality education until, in some respects, like in my case, until I went to prison and Goucher, through private funding, decided to bring the same education that it gave some people who college was a no-brainer because everybody else in the family been, right? So everyone else in this family goes to college, so it's no clue. We have no homework to do. You're gonna go to college, which school? Princeton, Yale, Harvard, etc. is the question, right? I also want to point, because so in thinking about this fiscally, $36,000 a year is costing the citizens to incarcerate an individual, where in-state tuition is less than $6,000 a year. So I just want to point that out. In addition to the thing that happened for me anyway, with being in a college classroom and around professors, a person has a character to endeavor to live up to. But if I never get exposed to that, how is the idea that I'm going to bring myself up by my own bootstraps, be released, and just amazingly have different behavior? There's a concept stated in bounded rationality, like these are known things, right? Bounded rationality holds that I'm not going to do anything new until given a new experience. Now, I do understand that doesn't do anything to weaken the blow of what happened to a community, but like myself and other individuals, we then go on to be the individuals that have the ability to go back into these communities and affect positive change if it's this through one individual. So I now sponsor 6 individuals who don't have dads and who are quite frankly on a track to go to prison if individuals are not constantly checking their text messages and checking in with these young men, right? Who else will do that work but somebody who's been that path? And I have the credibility through my past to say, hey, I've been there. So I don't get discredited when I say something to these young men. I'm speaking from a position of, I've been there, where you're headed if you don't change. However, you could also do this. So I do know how to get individuals. Part of my job as a recruiter is to get individuals signed up for college who never even imagined that college was on the menu, right? It wasn't on the table. So we're talking about a process through prison. P2P offers a number of wraparound services to get an individual who never even thought about college involved in college and go on to pursue a PhD if they so endeavor. So I just want to mention that because I am a violent offender and my crime did include a gun. However, I don't excuse my behavior. It was the worst thing I did. However, in that environment, what Goucher did to me by bringing that education was they allowed me to think of something else. And it's that's what I hear when you talk about giving an individual ability to earn an additional 30 days off their sentence. Is not, you're not punishing that individual anymore by keeping them in for 30 days longer, but you are telling them, hey, for something good, you get something good. And like I tried to explain in my personal anecdote, in my house, just not getting a beating or thrown out the house was the reward. Not that you got to be on this homework, and I'm so proud of you, because mom was doing 3 jobs and didn't see education as a way herself because she didn't get it. You know, my mom finished in 11th grade. However, she still was my mother. So I just want to point that out, that now I just was accepted into Johns Hopkins Masters of Public Health program, and I'm now awaiting the Bloomberg Fellowship to see if I'll be accepted. I don't want to be rewarded for the bad I did. I just want to say that if given the resources and opportunity, there is redemption, especially for people who were less than 25 years old before they offended. These individuals are not 40-year-old men and women doing these crimes. They're 16, 15, 17, 18. They're babies, and they have access to Army certified weapons with emotions, no dads and moms probably in the street. I don't, I'll end my rhetoric with that, but I just don't want that to be remiss.
Thank you very much, Mr. Freeman. Thank you very much. There are several other questions that have popped up here. I believe the vice chair is going to have to jump off for a second, so I'll take the next couple. But we have delegates Conaway, Arakan, and McComas with 3 questions. If anybody else has a question, please let me know by raising your hand or going in the chat. Starting with, we'll go with Delegate Conaway, then Delegate Arakan.
Thank you, Mr. Chairman. Thank you, Delegate, for bringing this bill. My question is, if I spent $30,000 or $40,000 to get my bachelor's degree, let's say, and went to a school and paid for this out of pocket, how should I feel if someone gets their PhD or their bachelor's degree while they're incarcerated for free and they get diminution credits? How am I supposed to feel about that?
Delegate, I think that you should feel like your community is going to be safer. I think you feel like we're using state dollars to ensure that those are providing incentives to individuals, as Mr. William just communicated. He was able to really come back into his community and really be a mentor and also able to see a different way of life. So I think that there are many positives in terms of making sure that we have legislation like this that is incentivizing education. So I think that it's a positive thing.
Well, I'll make sure I think of that when I pay my Sally Mae bills. Thank you.
Thank you very much, Delegate Conaway. We'll go to Delegate Arakan.
Thank you, Mr. Chair. I'm a little confused. Does the state actually already pay for these education programs? I was under the impression that the universities had sort of set up sort of their own, they were doing this for free, or it was a sort of in-kind donation. Is this something that they're paying for? That's my first question. And my second question is, I love the idea that people are trying to get themselves ready to go into the outside world and they just want a chance to get better. I'm not opposed to them getting educations in prison. I think it's a great idea. I'm confused though, why is getting the education not the reward? Why are we also asking the state and then the victims to essentially bribe these people to get a degree instead of them just desiring to get the degree because they know they're going to get out? These are all the people that are already going to get out, as we've heard today. Why are we also having to bribe them to do so with diminution credits instead of just saying, hey, you can get a degree, this will make your life better, you should do it, and then saying, great, I can't wait for the opportunity to do that. Now we're sort of having to bribe them. That part is confusing to me. I don't understand why that part is even necessary. Thank you.
If I can, especially to your second question, I don't think it's a question of bribery as much as it is incentivizing. I think that Will did a really good job of explaining how some communities have been robbed of a lot of different resources. As a young Black woman that grew up in Baltimore, I can speak to that firsthand. I went to one of the premier Baltimore Polytechnic Institute, and the school that I went to literally did not have heat in the winter and did not have air in the summer. And so students, the quality of education that some students have access to is non-existent. And once you recognize that there's a lack of value in education for you or your community, that same rhetoric and understanding education or the value of education is then pushed off from the individual and their disposition towards the education system. And so that incentivizing of education within correctional institutions, like Will stated, before, his, becoming incarcerated, he did not have a value for that education. And then once he was exposed to it, there was a level of appreciation. And I think that that's important, that incentivizing portion. I don't think it's bribery as much as it is exposure and incentivizing and showing that with good comes good.
The only thing that I would add to that, Delegate, and completely appreciate that question, is that right now, the way that diminution credits work, they already exist, right? We are not creating diminution credits. These are, we are adding onto the program this reward for a monumental achievement of receiving a certificate or a degree while incarcerated. Currently, though, the way our diminution credits work is that, as I mentioned in my testimony, that whether you are working in the laundry room, which is absolutely work with dignity, or working towards your degree, they are worth the same amount when it comes to diminution credits. So what I am saying is that because of the benefit to our community, to the incarcerated individual of earning a degree, what we are saying is that should have a higher level. There should be some type of reward for that achievement in our already existing diminution credit program. So that's what we're trying to get to here in this bill.
The answer to the cost question is by state law, if you're, I think, under the age of 21 and you don't have a high school degree, that the state is obliged to provide at state expense those GED classes. Beyond that, I think that the Division of Corrections looks for outside funding and participants. They have Pell Grants, they have volunteer programs with faculty from Goucher, Georgetown, a lot of places. The Pell Grants were cut off for many years and have just been reinstated. So we're hopeful that there would be more opportunity for folks to actually pay for college degrees that would be appropriate for them. And again, we think the expense to taxpayers would be minimal. The study by the Rand Corporation suggested because of the reduction of recidivism, every dollar spent on education in prisons is worth multiple dollars savings to the taxpayers because of it reducing the revolving door of people who otherwise would come back into prison.
Very quickly before I go to Judge, and this is to the judge, to the delegate, and a couple others, before I go to Delegates McComas and then Fisher. We've talked, I've heard about the studies, and Delegate Wilkins mentioned the studies. There's a lot of mention of studies. Has there ever been, or has DPSCS actually done a study, let's say from the last 10 years, saying here are the people who have gone through the GED and the BA programs and other technical training programs, and here has been the result year on year? Have they ever done that?
I'm not sure about the education programs. I know that the vocational certification folks at Correctional Enterprises, they did one several years ago and found that their successful graduates of MCE had a recidivism rate of just over 10%, which is compared to the normal recidivism rate of over 40% in Maryland when it was last reported. So it's a very good effect for the vocational certificates. I'm not sure that Maryland by itself has done its own checks to see how good the GEDs and college degrees are, but the studies around the country generally suggest that it's a good effect between something like 10 and some say as high as 40 or 50%.
We have also had conversations with Director Rojas from Corrections, who is in charge of reentry. And so they do have those numbers. We can submit those to you all via email.
I might be interested in a more comprehensive study. I'm not sure if that's this or another time, but we'll go from that. I also will say before I send it to Delegate McComas that Ms. Johnson, your Craven reference to the Baltimore Polytechnic Institute was noted and appreciated for the record. Delegate McComas.
Thank you, Mr. Chair. Just a quick question. I think, getting degrees and getting educated or getting vocational certificates in the prison system is a good idea. What I want to know, though, is that these folks are going in and some of them are going to be in there for a long time. And is there some type of program, I know that they get, they figure out where they should go with the classification and what their needs are and how far they went in school and everything. But it seems to me that there should be a real focus on helping them become adults because, and learning how to handle conflict, confrontation, dealing with life in general. And I just was wondering, because a lot of times folks will go into the military and that has saved them. Kids, in fact, we have one delegate who even talks about it. And I think you all know who I'm talking about. And he's, he's an attorney. He's very charismatic. He's a delegate, does a great job. And I guess the thought is that if we could kind of work on these folks in the beginning when they get into the system, even though they've been sentenced for a good period of time, to get them to see that getting involved in these programs and not getting in trouble in the prison system, trying to stay clear of all the contraband and all those issues would be helpful. And I wondered if there's any type of programs that really, work hard on them as they come into the system to prepare them to do well and help them when they get out. Front end as opposed to back end help.
Right. If I could answer that, there is a bill that we introduced and was passed a couple of years ago to work on that orientation process. But there's another bill coming up this session, which is called the Model Prison for Youthful Offenders Study, which is very much what you're talking about, focusing on offenders who are age 25 and under coming into the system, not excluding folks with violent crimes of violence, and working on issues of character, of how to organize oneself day to day, how to avoid conflict. Other states that have adopted these model prison programs, for example, the state of Connecticut is the oldest one in this country, have found that their recidivism rate has at least been cut in half for young offenders who have completed that program. And the number of assaults between inmates and prisoners in the model prison units are zero, no assaults, which considering the issues of character and violence in our prisons is an amazing accomplishment. So we're hopeful when that bill comes to your committee soon that you will give that favorable consideration as well.
Thank you.
Having technical problems on this end. I apologize. Are there further questions for this panel? Delegate Anderson.
Yeah, thank you, Mr. Chair. I want to go back to Mr. Freeman, who I thought made a very extremely powerful presentation with regard to his personal experiences. And one of the things we've been talking about is, yeah, okay, it worked for you. And what kind of statistics do we have for others? But maybe you could provide some more anecdotal information about people that you know who went through the same process and achieved what you've achieved.
Sure. So I'm sure I could mention one that might be pretty, at this point, famous, especially locally, in the name of Chris Wilson, the author of Master Plan, who had life in 5, sentenced at age 16 for a murder charge. However, in addition to him, there's Stephen Edwards, who now works in Palo Alto, who also had a life sentence, gave the life plus 45 years, gave that life sentence back, learned code while he was in something that was offered at Patuxent. He was able to learn some code language and went on to become a programmer. Dante Smalls, who was the forerunner and the first graduate of Goucher's program, who also is a computer programmer. I could name names for days of individuals, because also the thing that happens in these programs is that we become a family in ourselves. So then we move as a unit. So I could name names for days. We stay in touch. We do Zoom meetings. There are some people in Baltimore who are really instrumental. Dr. Stanley Andrees, the founder of From Prison Cells to PhD, who has his, he's an endocrinologist practicing at Hopkins, sitting on the admissions board for the medical school at Howard University, 10 years for felonies, drug offenses, some violent. Again, the idea is that we don't just become this individual who's successful, we become this conglomerate of individuals who are still connected to our communities, because there's still issues. It's not that once you get the degree, your life is just this rose that buds, right? You still need someone to honor that degree, and you still need someone to help you get better housing, because there's still systemic issues around what prevents an individual like me from moving forward. And we can't get that done without someone on the inside saying, hey, I'm willing to give you a chance because you've done these things, right? Getting individuals to do the things, if I could. Again, I started a t-shirt movement called Formerly Incarcerated. And the t-shirt, pretty much, it cost about $9 to produce, and it sells for $30. The whole dollar amount goes to what the JOTF is, and Delegate Wilkins is proposing, is to incentivize the idea that, hey, we need to counter this culture of violence. Because if no one is countering that culture of violence, it's being handed down. You know what I mean?
Let me ask you another question. Let me ask you another question real quick. I think Delegate Conway brought this up, but how does an inmate, or what schools are now providing these kind of programs? I take it they provided them for free or for low cost, right? So
right. So
colleges are doing it.
So Goucher, again, I'm a graduate of Goucher, so I'm pro Goucher. They do it out of 85% private funding before Pell. So Goucher was one of the schools. So they actually launched Obama's administration. Arnie Duncan and Loretta Lynch got a chance to meet them at MCIJ. They came in when they launched the Second Chance pilot program. So that institution was a part of that. Goucher was doing it. University of Baltimore was doing it through JCI. However, I think the way they were doing it was that if individuals had some source of income, if they worked in the shop, they were doing it on like a sliding scale, and even have individuals pay for their own educations. This is pre-Pell. Bard's been doing it for, in upstate New York. They're kind of like the forerunner and the model for many programs across the country. I also know Rutgers University offers a program that is paid mostly through private funding for people who are incarcerated in the state of New Jersey.
Okay, let me ask you one last question. With regard to how long it takes.
Sure.
A person who gets a 4-year degree at a regular college, it takes 4 years. These English credits, 72 credits per semester, whatever, it takes them 4 years.
Sure.
Inmate who once he achieved his GED or his high school diploma, and he wants to get a 4-year degree, or quote unquote 4-year, how long would it take him to get it, do you think, or her?
So because of all the external factors, an incarcerated person who gets a 4-year degree in prison could do it in 4 years. If they go full-time, myself, my first 3 semesters, I took 5 classes in addition to working in the MCE shop. So if you're willing to take on that workload, you could also do it in 4 years in prison. Again, that's provided that the classes you need are even available, because they still want like a group of individuals to move through. Like, so one person can't take off and do pre-calc. You need about 8 individuals with Goucher's program. They wanted at least 8 students in a class before they did an enrollment in that class. So I guess it depends on the program. Me, I joined Goucher's program in 2014, and I just graduated May 25th, 2020. And that required, for my judge released me from prison because, again, with the parole board and the politics, although I had earned diminution credits, I think Corey Johnson had mentioned this, although I had earned those diminution credits, that didn't lead me to release through parole or anything like that. It just brought my parole date down. So I served 20 years. And then when the parole board, they told me, in fact, what they wrote on my paper was, you need more education. Despite the fact that I had attained 83 certificates, completed 5 vocational trades, I'm also certified in HVAC and electrical wiring. Despite the fact that I had this portfolio that was this big, and a support of individuals also from victim impact, saying that this individual may deserve a second chance, parole board did not grant me parole, and Judge Charles Peters took it upon himself to say, and discuss that I'll release him. And
Okay.
he released me.
All right. Well,
I
thank you
would
very
have
much.
still been incarcerated today if it wasn't for Judge Charles Peters.
Yeah, he's a good judge. Thanks.
Thank you all very much. I believe that concludes the questions that we have on this piece of legislation, and I appreciate everyone's comments, questions, and testimony. That concludes the testimony on this bill and the testimony on the bills today for the House Judiciary Committee on January 18th, 2021. We will be back tomorrow with more fun and excitement. We hope you will join us then. Thank you very much and have a good afternoon.
Thank you, colleagues.